everyone, and welcome to this Federalist Society virtual event. My name is Edith Harold, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host this FedSoc forum, Non-Delegation Doctrine Adds Another Good Year. Speaking on the topic today, we have Jeffrey Bielert of Stein Mitchell and Trent McCotter of Boyd & Gray. Devin Watkins will be moderating today and is an attorney at the Competitive Enterprise Institute. If you'd like to learn more about today's moderator or speakers, their full bios can be viewed on our website, fedsoc.org. At the end of the program, we may turn to the audience for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers and not the Federalist Society. With that, Devin, thank you for joining us today, and I'll hand things over to you.
Thank you very much. The case we are here to discuss today is Consumer Research v. FCC, which was decided by the Fifth Circuit en banc. In that case, the Fifth Circuit en banc held that the Federal Communications Commission's Universal Service Fund is unconstitutional. According to the Fifth Circuit, it violates the non-delegation doctrine, which limits how much legislative discretion can be given to agencies. I have two experts with me who will help provide some insight into this case, the non-delegation doctrine, and its impacts going forward. First is Trent McCotter, a partner at Boyd & Gray, which is a great boutique appellate firm here in DC. He represented consumer research before the Fifth Circuit in this case. Before joining Boyd & Gray, he was Deputy Associate Attorney General overseeing the Department of Justice's civil appellate and federal programs litigation, where he helped craft the federal government's appellate strategy. The second expert we have is Jeff Bielert. He's a partner at Stein Mitchell. Before he joining that firm, he was also a Deputy Associate U.S. Attorney General, although at this time in the Environment and Natural Resources Division before he worked at the Office of Legal Policy, helping to evaluate potential judges. He represented the Competitive Enterprise Institute, where I worked, and several other organizations, and in an amicus brief in this case. With that, I will start with asking Trent McCotter to help explain to us your views on this decision by the Fifth Circuit.
Thanks, Devin, and thanks to Jeff for suggesting this webinar. I appreciate it. It's a good idea. So, as Devin said, I'm Trent. I'm at Boyd & Gray in Washington, D.C. Our firm represents the challengers in all of the Universal Service Fund challenges. There is a new quarterly USF rate that comes out 4 times a year. So every quarter we file a new lawsuit. We're here primarily to talk about the Fifth Circuit decision. That's the one that's in the news. We also had challenges in the Sixth Circuit and in the 11th Circuit to kind of help pave the way. As Devin said, like the basic background here is the FCC raises, it turns out almost to be $10 billion a year for the Universal Service Fund. If you check your monthly cell phone bill, you probably will see a line item on there. Maybe $1, maybe $5, usually not a huge amount, except when you add it up over 100 million phone lines, maybe more, it ends up being multiple $1 billion every year. And then that money goes into a big pot and it gets redistributed back out ostensibly to improve phone service across the country. But there's just a few problems with how it's actually been implemented. Congress and the statute that created all of this didn't impose any kind of limitations, any kind of formulas, anything that kind of tells the FCC what to do. And I'll talk about that a little bit more in a second. And then the FCC says, we don't want to deal with this either. Congress gave it to us, but it's this kind of political hot potato. So they offload it to a private company called USAC, Universal Service Administrative Company. USAC is run primarily by people with telecom interests. A lot of them work at telecom companies. Every quarter, USAC decides largely how much money do we think we need for universal service? And then that number becomes binding unless the FCC steps in. It's kind of a default process that plays out every quarter. Plays out right before the new quarter begins. So the FCC largely has no choice but to just accept what USAC proposes. The Fifth Circuit said, the statute itself that gives the power to the FCC is largely bereft of any kind of principles. There's a lot of words there, to be sure, but any kind of limitations are missing. And the Fifth Circuit said it sure looks like that violates non-delegation, but we don't quite need to go that far. They then said the delegation from the FCC to this private company, USAC, also really looks like a private non-delegation problem. You're offloading this decision of how many billions of dollars to raise to people who have no government position whatsoever. But again, we don't have to quite say that's a violation. And the court's holding, its true holding, is that the combination of all this violates non-delegation. At the very least, the lack of responsibility, the lack of connection, the lack of oversight violates Article 1, Section 1, which vests legislative power with Congress, not with the FCC, and certainly not with a private company. So the opinion that came out from the Fifth Circuit is an en banc opinion. The majority opinion was written by Judge Oldham, joined by 8 other judges. And I wanted to cover a few parts of that opinion that really stuck out to me upon rereading it now with fresh eyes. It came out a few months ago. So in particular, near the beginning of the opinion, the Fifth Circuit spends a fair amount of time on why this charge that shows up on your monthly bill should be considered a tax rather than a fee. Now, in the briefing, we spent time on this. I think it's important kind of optically, but the issue is the FCC never really disputed that this is a legislative function. Whether you label it as a tax or a fee, they're raising a lot of money. The FCC's argument was about how there's an intelligible principle. So why did the Fifth Circuit kind of lead off with this really kind of aggressive section saying that this is absolutely a tax, not a fee? The FCC had insisted it was a fee. And I think honestly, a big part was that the court wanted to show that the way the FCC describes the system just does not match reality. A fee is typically something that's like a quid pro quo. You know, you pay 80 bucks and you get a passport. You pay 20 bucks and you get into a national park. It's like a one-off decision. It doesn't have like a widely shared benefit per se. A tax, though, typically, a bunch of people pay in and then the money goes back out for the public interest. The Fifth Circuit says this isn't even a close call. It is so obviously a tax. And again, that it leads to the next part of the case about how this involves a legislative issue. But again, I think a big part was that the court wanted to just say to the FCC at the very beginning, you keep describing the system a certain way, but reality does not match. So they say that. Moving on to the next part of the analysis, they say, okay, so it's a tax. It's a legislative function, therefore. Congress can't delegate its legislative powers. Or to put it another way, it's not a delegation if there's an intelligible principle. That's the current case law, the current precedent. The Fifth Circuit stuck with that. They realized that. And so what was interesting there to me, it's a long section, I won't go through it all, but the most interesting part was how the court used the FCC's own words against it. So in prior cases, back in the 90s, the early 2000s, when non-delegation was kind of just a joke and Chevron was at its peak, every time the FCC faced a lawsuit over Universal Service Fund issues, they would just say, come on, look at the statute. The statute has a bunch of words, but it's all like tautologies. It's all labeled as things that should happen, not must or shall, or almost all labeled that way. And so what the FCC said is, sure, the statute says like universal service should be affordable, universal service should be equitable, that sort of thing. But those are aspirational only. That was the phrase the FCC used for decades. And so we looked at that and said, well, that sure sounds like a non-delegation problem. If the agency itself says it's limited only by its own aspirations, like, gosh, the sky's the limit there. And so that's what we argued. And the Fifth Circuit agreed with that. And they kind of called out the FCC for saying, well, it's funny, for decades, you claimed that the statute essentially has no meaningful limitations. You get a non-delegation challenge and suddenly you claim that it's got all these restrictions and it's so tightly confined and cabined and that sort of thing. And so again, it's like a good example. The Fifth Circuit was just not buying the FCC's presentation. The next part, the court goes through Supreme Court precedent on non-delegation. There's a lot of cases, I won't go through them all, but a lot of cases that bring non-delegation claims, the courts will just say, look, the Supreme Court has said a statute can use a phrase like in the public interest, and that's good enough. So how could anything ever possibly fail? That's what a lot of courts do, and that's kind of the end of their analysis. Our briefing had said, hold on, you need to read these cases more carefully. A lot of them involved government property, which might be subject to different non-delegation principles, or maybe not at all subject to non-delegation. A lot of them involved really technical aspects, regulating the airwaves, setting particular pollutant levels. Some of them were cases where Congress used what seems like broad language, but then tied it to something really specific. There was a case where the court said that the agency needed to set prices that were fair and equitable. People often cite that. Well, gosh, if that's good enough, then anything is. But the statute there actually said fair and equitable compared to prices on a specific day in the 1940s. So the agencies were really restricted in what they could consider. So the Fifth Circuit really went through case by case every single major non-delegation decision the Supreme Court's ever issued and kind of put them into buckets and said, what we have here with the FCC is a different kind. It's a case where there's obviously a legislative power, taxing, revenue raising, but yet Congress gave no real limitation. It's all just tautologies, aphorisms, remember, aspirational only. And so they said, and I think this is right, there's really no Supreme Court case that's ever addressed a statute like this. So that's another part that really stuck out to me, is the fact that 9 judges on the Fifth Circuit spent page after page going through every single Supreme Court decision, when most circuits kind of just give it the back of the hand when you bring a non-delegation challenge. On the private non-delegation aspect, the part that involves the FCC handing this over to USAC every quarter to figure out how much money they want, the court focused on 2 aspects, and I think they're right to focus on those 2. The first was that this USAC entity is self-interested. They have an incentive to raise the numbers higher. It's reminiscent of the line, I think it's from Carter Cole, the Supreme Court decision, where the court said this is the delegation of power not to some disinterested entity or a government entity, which hopefully would be the same, but to kind of industry competitors who have an incentive to kind of manipulate the market. And the Fifth Circuit spent much more time on that issue than our briefing had, to be fair, but it was obviously something they thought very important. The second part, which was one that I thought was actually more important, is the fact that there's no evidence the FCC ever actually reviews what numbers USAC puts together. There's no order that comes out each quarter that says we've looked at those numbers, they're looking great, we adopt them, we've independently reviewed them. Nothing of the sort. It all happens by default. And the line that the Fifth Circuit gave, and I think it's kind of an intuitive example because it's something that I would think most people would agree is beyond the pale, is that you can't have a statute that says the defense budget is whatever Lockheed Martin wants it to be unless the government intervenes to revise it. And so it's the same situation here. There needs to be some sort of independent judgment by a government official or commission actually adopting this. The last point that I'll make about the Fifth Circuit's en banc opinion, the FCC kind of predictably beforehand and even after has said there's going to be chaos if this challenge succeeds. Universal service is going to be destroyed. People won't be able to have cell phone access and all that. And of course, none of that's true. First of all, the Fifth Circuit opinion did not vacate anything. It just remanded to the agency. So even under the Fifth Circuit's opinion, if it were fully affirmed, the FCC just gets it back. And in the meantime, they can try to fix it. Also, to be honest, Universal Service Fund has been in kind of a death spiral for years now. More and more money getting sucked out of it, less and less money going in. There's been a lot of debate about how to fix it. Should Congress just appropriate money every year? Should the FCC try to broaden the contribution base and draw from big tech companies, that sort of thing? Could the FCC do this by reg? Does it require a statute? It doesn't really matter. The point is, there hasn't been that political impetus to actually change anything. And so honestly, I think that the best thing that could happen for universal service would be for the Supreme Court to affirm the Fifth Circuit, because I think it would finally give that political impetus to create a universal system that actually works and makes sense and is sustainable, and most importantly, is constitutional. So those are my thoughts, kind of rereading the opinion now, going back through it again to see which areas the court really focused on and which kind of like which issues are ones that maybe the Supreme Court will focus on. We can talk about that in a minute, but those are my kind of takeaways from what the Fifth Circuit did, Devin.
Thank you very much, Trent. So Jeff, what are your thoughts on this court opinion?
Sure. Well, first of all, thank you to the Federal Society. Thank you to Devin and Trent. It was sort of my idea because I do think this is a big case. It's an important case. And sticking with sort of the theme of the webinar, since the 1930s, this hasn't really happened, right? We haven't had circuit courts finding statutes unconstitutional under the non-delegation doctrine. And I think to Trent's credit, as the lawyer that brought this, I mean, this case from its inception was always a non-delegation challenge. So instead of raising other arguments to challenge this particular statute, this case was always presented as a pure non-delegation challenge to this statute. And one of the things that I think is somewhat interesting, you saw this in like the West Virginia versus EPA case, where the parties were raising non-delegation doctrine arguments below, and then when they got to the Supreme Court, it became all about the major questions doctrine. So that a lot of litigants, they'll make the non-delegation doctrine argument, but it's a constitutional argument, and it's not one that usually gets decided. Here, it's the exact opposite. These cases were designed as non-delegation doctrine cases, and it sort of forced the court to address that constitutional issue. So, it is rare. I mean, it hasn't happened. I think the Fifth Circuit was a horse betting case that I think is also currently pending before the Supreme Court, where you had a non-delegation challenge. But this decision by the en banc Fifth Circuit, I mean, it's over 100 pages long, and it, as Trent already described, is very detailed and is unique in the sense that it walks through the analysis that Trent already laid out, that the court is actually grappling with the Supreme Court precedent in the way the court has described the non-delegation doctrine. And to me, that's what makes this case so unique, and what makes this decision by the en banc Fifth Circuit worth reading. And hopefully it is currently pending. I think the government filed cert on this. Is that correct, Trent?
That's right. The government filed their cert petition off of this opinion about 10 days ago. And so it's still in kind of the cert stage part of the case.
Have you filed your opposition yet?
Well, so we filed
Not opposition, sorry, your response.
We filed a response because, as I mentioned, we filed a lot of these suits before this one. Every quarter we file a new one. We'd filed in a couple other circuits, the 6th and 11th. Those courts rejected our arguments, although the 11th Circuit had a really great concurrence by Judge Newsom saying essentially we should win, except the Supreme Court just needs to change doctrine in the meantime. So we sought cert off of those ourselves. Those are still pending. And so when you have your own cert petitions pending on issues, it's kind of hard to oppose the other side seeking cert from a different court. So we filed a response saying, yes, there's a circuit split. These issues are important. The Supreme Court should grant them. Please just grant our case, because our case is the lead one. We've been here from the beginning. We want to be petitioner, that sort of thing. And the Supreme Court hasn't yet set it for a conference. It'll probably happen in November. But I assume, high probability that they're going to grant one of these petitions.
So it, I guess, would be decided potentially this term. Is that right, on the schedule?
Right, if they do grant. And as I said, high probability, you never know for sure, though. You can never say for certain. But if they do grant, I think argument would probably be around March or so. So in enough time to get a decision by next summer.
And
okay.
Sorry.
Let me ask a couple of questions myself to try to expand upon this a little bit more. We've all read the Supreme Court precedent on the non-delegation doctrine. Textually, that goes back to the legislative vesting clause in the Constitution. But many people read the legislative vesting clause not to have a non-delegation doctrine at all included in it. How do we know that the legislative vesting clause has this kind of idea of a non-delegation doctrine kind of incorporated into it?
So the best explanations that I've read, it's kind of a two-part inquiry, two-part analysis based off of what's admittedly one sentence, is that it says, first of all, that the legislative power shall be vested. So focus on the shall, and that's kind of an overlooked part. And there's a pretty good argument that by saying shall, the Constitution means like it must be there. That's mandatory. And that also means it can't be sent somewhere else. And just in case you had any doubts, the second part is it says it's vested with Congress, and there's no vesting of this power anywhere else. So there's no other part of the Constitution that even kind of suggests that Article 2 or Article 3 somehow is vested with that kind of power. And it's the same, relatively for each branch. The Article 2, Section 1 says the executive power shall be vested with in a president. There's nowhere in the Constitution that suggests executive power is vested somewhere else. Article 3 is the same. It's the judicial power shall be vested in one Supreme Court and whatever inferior courts Congress creates. And so there's like this very clear parallel use of language. There's kind of this affirmation of power used with mandatory language that is then absent from any other part of the Constitution. So to me, that's where it comes from. Obviously, the Supreme Court has recognized non-delegation for 200 years. If you go back to the Wayman case written by Chief Justice Marshall, so it's not as if this is some new doctrine. I will say some of the Supreme Court cases in the 1930s that found non-delegation violations, to be fair, use some language about due process and how it could violate due process to have either private entities or kind of like the wrong government entity using power. I don't know, I guess I could see that in like a generic sense, but I don't really think that's where, at least when it comes to federal power, I don't really think that's the basis of any kind of non-delegation doctrine.
So assuming that we have a non-delegation doctrine, how far can Congress go appropriately to delegate power to agencies? Can it say, go do good things? Can it say, go act in the public interest? Can it say, go act reasonably in this area? Can it say, go make sure the water is clean and pure? And whatever that might mean. How far do you think Congress can go? How specific does it have to be?
I mean, it can be really broad, right? I mean, that's what we've seen since the 1930s, is that Congress actually has been incredibly broad and has done it certainly in the context of environmental statutes, where you see they're giving authority to the EPA or an agency, and they're doing so similar to what you just said, right? I mean, make sure that the water is clean. And then the EPA will go out and have regulations, or they'll use that authority to set the limits. I mean, Congress is not very specific, but the point that Trent made, and I think that this is important, and for the FCC here, there are principles laid out in the statute itself. So the statute goes through and says, you're going to provide this universal service fund, this program, according to these principles. And Congress laid out various principles. The FCC in its briefing argued, well, this is the intelligible principle. This is the test that you apply. We must administer this program according to these principles. You see that in other statutes too, that the court has found are constitutional. Here, not only did it have the principles, but there's at the very end of it, it's like, and whatever principle that you want. So the FCC itself, under the statute that Congress passed, can come up with its own principles by which it administers this particular fund. So here, I haven't looked at like all the statutes that have been subject to non-delegation challenges, but here you have a statutory provision that it just opens the door to the FCC doing whatever they want. And I think that argument also resonated with the Fifth Circuit. The fact that, yes, not only are they aspirational, but that the agency itself gets to decide what its principles are that it regulates this fund. And the other thing I'll add is, and this was in the briefing, that a lot of these cases, or a lot of the statutes where you had non-delegation challenges, there would be some sort of limit, or there'd be some sort of a very broad grant of power, but it would still be cabined in some way. And that's not in this case. The way that the FCC is able to administer this fund the way that Congress wrote the statute, it's incredibly broad. And we said this, that the FCC one quarter could set it at $15 billion and the next quarter at 0. And there's no statutory requirement one way or the other. And so here, I think with this particular statute, what you have is you have this really broad delegation, but you also have no limitations put on by Congress. And to me, that's another important point of this, because other statutes, you typically see Congress setting some sort of limit or telling the agency what it must do in exercising really broad grants of power. Here, you didn't have that.
Yeah, so Devin, kind of to go to your question, I took it to mean kind of like, what's the right answer under maybe like an originalist view of how far Congress can go and that sort of thing. And I think a lot honestly turns on whether the power at issue is determined to be legislative. So I haven't researched it fully, but there seems to be pretty strong historical practice saying that Congress, let's say it constitutionally raises $1 billion, and it could just hand that money to an agency and say, here's $1 billion, do good things with it. I think that would probably be fine because the spending of money is treated differently than the raising of it. And that's why we really made sure to be careful here that we're challenging the revenue raising aspect of it, because revenue raising, in my view, and I think in the view of a lot of scholars, is like the primary legislative function, like ironically, even more than actually legislating. Parliament was created not to pass laws, but to raise money for the king. It was only later that they actually started imposing legislation as we think of it. And so like raising money is kind of the core fundamental thing that you have a legislature for. And if they can delegate that to the executive branch, then like everything is fair game. So on some of your other examples, like could Congress say regulate in the public interest? I think if that's all they give, I mean, that might fail even now, to be honest, because the Fifth Circuit, as I mentioned in its en banc opinion, talked about this. Sure, there's a case that says the FCC can regulate in the public interest, but in that case, it was arguably government property that it was regulating. And at the very least, it was this highly technical aspect. We don't expect necessarily Congress to be the expert when it comes to really technical stuff, but on deciding how many billions to raise for what is, I think, kind of admittedly a welfare fund, that's core congressional authority. And one of the points I didn't mention is the Fifth Circuit let off a lot of this analysis by citing Supreme Court cases going back decades saying what counts as an intelligible principle for non-delegation will vary based on the context. Supreme Court said that, so the Fifth Circuit took the court at its word. When it comes to really technical scientific stuff, we're going to be pretty hands-off, I think, if we're courts. And under an originalist view, maybe the court's a little more stringent, but I don't think they're going to want to be policing, pollutant levels like there were in the Whitman case. But when it comes to the big stuff, like raising billions of dollars for in taxation for a nationwide program, that sort of thing, well, that seems like the kind of thing that maybe Congress should be the one to set limits on or to set rules on. And like Jeff said, the statute here has a lot of words. This was a line that Judge Newsom had at oral argument in the 11th Circuit. He says there's a lot of words here, but it seems like that's all they are. They're just words. It's just a lot of words. They don't actually tell you anything. They don't impose any restrictions. So I suspect that if the Supreme Court granted, and if they were to affirm on kind of like an originalist view, that sure, that means this program and the way it's run right now is going to be declared unconstitutional. But this idea that the government raises that like the entire administrative state will fall, I think it's honestly just not correct. There certainly will be more challenges and courts will have to sort it out a little bit, but a lot of the cases the Supreme Court has addressed on this are very ably explained in the Fifth Circuit's opinion, which found non-delegation violation under current principles. So sure, like Congress should be more specific and would have to be more specific in certain cases, but I kind of suspect a lot of things would still pass muster. And in fact, if we want kind of proof of it, after this Fifth Circuit opinion came out, the Fifth Circuit's already issued an opinion in a completely unrelated case about a Department of Labor regulation that when you read the statute there, it's pretty broad, not a whole lot of definition. there, and the Fifth Circuit said, yeah, it's pretty minimal, but even under consumers' research, our en banc opinion, we think this is probably enough. And that opinion was written by Judge Elrod, which is noteworthy because she concurred in the en banc opinion and said the majority is not going far enough. All of this is unconstitutional. Let's not stop short and say only the combination of these various delegations is unconstitutional. Every single part independently is. But yet, a month later, she's already rejecting a non-delegation challenge.
The Fifth Circuit en banc also discussed the common law of agency principle, that no delegated powers can be further delegated. How does that get involved with the non-delegation doctrine, and what are its implications?
So there's a footnote in the en banc opinion, which I'd kind of forgotten about, to be honest, until I reread it the other day, where the majority says, as it's talking about this delegation from the FCC to this private group, USAC, it says that the decision to delegate further is itself a legislative decision. And there's hints of that logic in the Whitman case for those who are familiar with this. And so I think the way that it really comes up and the way the Fifth Circuit uses it is to say, hey, by the way, we should be especially skeptical of this delegation to the private entity, because nowhere in the statute does it mention a private entity being involved for any purpose. There's no indication that Congress wanted the FCC to enlist the help of a private entity, let alone to the extent the FCC has actually done it. And so that decision itself to enlist USAC is very arguably itself a legislative decision that must be done by statute. And I think that principle is kind of the same principle you mentioned, Devin, which is, okay, fine, let's assume Congress gave the FCC this power. If Congress were to allow the FCC to delegate it to a private entity, at the very least, there needs to be that express authorization beforehand. You know, if the principal tells the agent, hey, agent, you can go hire a sub-agent, fine, go for it. At least in terms of like statutory authority and, you know, agency principles. But here that's missing. Now, having said all that, I kind of find it questionable that Congress could ever allow a delegation to a private entity. So even if Congress had said, hey, FCC, you can go hire USAC to run this whole thing for you, okay, that like knocks out one argument about statutory authority and sub-delegation authority, but still you've got Congress delegating the legislative function to a private entity. So I took that more as just like belt and suspenders. Like, you want really strong evidence that this whole thing is crazy? Like, well, here we go.
What do you think about the idea of that common law maxim that kind of existed before the Constitution as being the kind of a principle that creates its non-delegation itself, where the people, through the Constitution, delegate powers to Congress. Congress then can't turn around and delegate those same powers to the agency.
Yeah, we have a good quote, which I'm not going to be able to do it verbatim, from John Locke. Or Thomas Paine or whoever, I can't remember, one of them. I think it was actually Locke, but he was talking about Parliament, not Congress. And he said that the delegation of power comes from the people. The people delegated power to the legislature, and they delegated that power to make laws, not to make new legislatures. And so the power that Congress got in the first place, kind of under English principles, you could say, reflects all of the same idea that, like, the power that Congress has is something that shall be vested with them, i.e. nobody else, and also, i.e. don't try to give it to anyone else.
Yeah, and I think that there's sort of, Trent hinted at this earlier, but there's an accountability issue, right? I mean, legislators are elected by the people and they have to get reelected or they're going to run for elections. And so they are forced to sort of make decisions. And here, Congress basically punted to the FCC. I mean, the way that this statute works, they're able to raise $10 billion a year in taxes that shows up on our phone bills every month. And there's no political accountability. It's not like, a senator had to vote for this every quarter, or the House was passing laws every quarter, putting a number to this tax, right? They've essentially taken away any form of political accountability because the members of Congress can just say, well, that's the FCC, right? They passed this very broad law that allows the regulators to set the amount of this tax every quarter. And to me, that's another reason why I think when you look at sort of first principles, or sort of this idea that Congress is the one that has to exercise this power, right? And here, Congress basically let the FCC do it. And as Trent pointed out, this company, it runs the numbers every month. And it's not just the setting of the tax, but the doling out of the billions of dollars that they're collecting. So everything is being administered by a private company through that the FCC deems approved, the amount of money that it gets every month, and then turns around and picks the winners and losers. It's not Congress that's telling the FCC where to put the money. It's this private company going through the FCC to not only collect the money, but give it out to whoever it is that they're going to give the money to in furtherance of these very broad aspirational principles. And to me, like those are issues that typically you would see Congress raises the money and Congress sort of picks the winners and losers. Here it's the agency, and it's not just the agency, it's a private company. And I think that that's what makes this such a unique and unconstitutional delegation of authority.
So with that, we're going to start to accept questions from the audience. Please use the Q&A feature to submit your questions, and then I will take those questions and present it to the panel. The first question here, I am seeing many citations to Loper-Bright and the non-delegation doctrine and challenges in regulatory challenges. What do you think the future of non-delegation doctrine is, and whether SCOTUS does or does not hear this FCC case?
So a lot of people here, if you're watching, you're probably already familiar with the Gundy decision from the Supreme Court, which was, what, 2017 or so, I think. And Justice Gorsuch has this really long dissent in that case that was joined by Justice Thomas and by the Chief Justice, saying that, like, come on, guys, like, now's our chance. Like, we need to reinvigorate, quote, the non-delegation doctrine, because this is an important limitation. Like Jeff said, it's about accountability, it's about the text of the Constitution, etc. And yet, in that case, obviously, it failed. They couldn't get enough votes. Now, in the meantime, there have been some more additions to the court, and I think everyone's been kind of assuming at some point the Supreme Court would take up a non-delegation case. I kind of got the impression that, maybe after last term, they had a lot of big regulatory agency type cases, including Loper-Bright, as the questioner mentions, and that they were kind of maybe trying to have a pause, have a breath before they do non-delegation. But like the Fifth Circuit, its decision, as I said, carefully tracks existing Supreme Court precedent. The dissent, obviously, thinks that the majority's kind of out on a limb. I don't think they are. And so it's kind of like a perfect case, in my view, for the Supreme Court to take it. If they don't take it, I mean, I guess, the Supreme Court could wait until another non-delegation challenge comes along that's failed. But I think it's kind of too easy to try to take a case where the court below actually found a non-delegation violation. And I mean, I would be kind of surprised if the court doesn't take it. So that's all just to say, like, whether it's this case or a year from now or 5 years from now, they're going to have another non-delegation case. I don't know whether they're going to go full on and adopt what Justice Gorsuch said, if they're going to do something kind of in the middle. I could see them taking our case and kind of affirming the Fifth Circuit on this narrow combination ground, which kind of lets them all, move the doctrine a little bit without doing too much at once. I could see them taking it and saying, this is a tax, and taxes in particular need to have a little bit more. And so, it's kind of like a first step on non-delegation. Let's see how this plays out. I don't know exactly what they're going to do, but I think that sooner or later, an emphasis on sooner, they're going to have to take one. I think they want to take one.
Yeah, and I think I mentioned this earlier, but most cases that get to the Supreme Court, when you look at the cases that are decided that talk about the non-delegation doctrine, there's other issues in that case that are being addressed. So these set of cases are a bit unique because I think I mentioned this, that it's pure non-delegation doctrine, right? So in a way, the court doesn't really have another way of finding this program either on a statutory basis or, major questions doctrine. I mean, there's other ways in which you could say that this program itself is a problem. But here, those arguments were not raised below, and it's always been a non-delegation challenge. So the constitutional issue has sort of been front and center for this case all along in a series of challenges. So I do think that with the SG asking the court to take this case, and as Trent mentioned, the circuit split and the other two cases that he has pending on cert petition, I do think that the court is going to grant either the SG's cert petition or Trent's petition from the other circuits. So I suspect the court's going to grant this case. Who knows what they're going to do, right? I mean, you could see a decision, as Trent mentioned, that's pretty narrow, or you could see something, adopting the justice's views that they've articulated in other cases. So it'll be interesting to see what happens. I'm excited. I'm excited by this case coming up, hopefully this term.
The next audience question is, do you think the court will avoid the broader non-delegation holding by focusing only on the private USAC element?
So I think that's, yes. I mean, that's one out, right? I mean, what the court could do is you could say yes on that Congress can delegate to the FCC, and you could read it the way that I think the 6th Circuit and the 11th Circuit did, and say these broad principles actually do articulate and cabin this grant of authority. But to Trent's point, there's no mention in the statute whatsoever that the FCC then can rely on a private company. So you could basically get sort of a private non-delegation doctrine decision in which the court is striking down that element of this program because Congress didn't address it, because it makes it, you can't sub-delegate this authority. So it's possible. My own view is that the Supreme Court likely will need to address sort of the first level issue, the delegation to the FCC. And for the reasons that we've already sort of discussed and the arguments that have already been made, I don't think that this is a constitutional delegation for sort of the way that you read these principles. And Trent's right. I mean, the 5th Circuit did a great job, and Trent as a lawyer pointing out that the FCC itself, the language that the agency itself has used in calling this aspirational. And I think that's going to be hard for the government to get away from.
Yeah, so who knows what the court would ultimately do? The only point I'll add is it's very interesting in the government cert petition. They sought cert separately off of all 3 questions. So is the statute constitutional? Is the subdelegation to USAC constitutional? And is the combination of them constitutional? And their explanation for this is, okay, sure, the 5th Circuit didn't say in the end that the statute is unconstitutional. They didn't say one way or the other. And the same with the private delegation independently. But like logically, the court will probably need to address those issues, at least to some degree anyway. And so the government seems to be kind of asking the court to some degree, address all of these issues, not just the kind of the narrow 5th Circuit holding about the combination. So if the government's asking the Supreme Court to rule on the constitutionality of the statute, they might feel like, okay, well, if you want us to, then let's do it. Now, obviously, they'll do what they want in the end, but I think it is telling that the government was willing to put that in its cert petition.
The next audience question is, if Article 1 vests legislative power in Congress, and that's the basis for the non-delegation doctrine, why would delegation to executive branch agencies be more acceptable than delegation to private parties? To the extent that you're saying they might be neither are Congress.
So I think it's kind of hard to describe in like typical terminology. I think the answer is delegations of legislative power to the executive branch are equally unconstitutional. We just have to figure out what is actually a delegation. So we often use in like colloquial terms, Congress delegated to an agency the power to kind of fill in this gap or to decide this question. And it's a delegation, but it's not a delegation necessarily of a legislative power. And so what the Supreme Court has said is that it's not really a delegation of legislative power unless it fails to have the intelligible principle, or whichever test you want to use for it. So unless you fail that test, it's not actually a delegation in the first place. It's just legislation, and then the executive branch does its job of executing the law, engaging in fact-finding, that sort of thing. So I think like the question is, like the premise is correct, that delegations of legislative power to executive agencies are just as unconstitutional as it would be to delegate to a private party. It's just that kind of what counts as a delegation is up for dispute, and the court, to be fair, has not had a private non-delegation case in a long time. And so at least in the lower courts, the test for how much Congress can delegate to an agency before it becomes unconstitutional is different than how much an agency can then delegate to a private entity. And I don't know, the Supreme Court might say the test should be the same, it should be the same inquiry, it might be different, but a lot of this is just trying to figure out what actually amounts to a true delegation, which would be a prohibited delegation.
The next question is, to what extent does the Congressional Review Act, which allows Congress to pass a resolution of disapproval on new regulation, create a kind of cross-the-board Congress argument that Congress has retained its legislative authority over all of these agency actions?
I haven't thought of the Congressional Review Act in particular, but I think the point is probably that Congress, of course, can always change the law, right? Congress could say, we are eliminating the FCC. The whole thing's gone. USF is gone. Like, we're doing it all ourselves, or it's perpetually barred, whatever. Congress can say all of these things and take the power back. And like the bottom line is the Supreme Court has just said, like, that's not enough. Like the possibility of having new legislation to undo it is not enough to solve a non-delegation problem, because otherwise there can never actually be a non-delegation violation. And it's the same with an agency delegating to a private entity. The agency can always yank the power back. And Judge Ho had written about this in a separate case called Rettig in the Fifth Circuit a couple of years ago. And again, like pretty well established principle that like that just can't be enough, or else you would just never have non-delegation violations. We know non-delegation is a doctrine, and so it must be that that ability is not enough. And to the extent the question is saying, well, the Congressional Review Act is already on the books, so it doesn't require new legislation, as a way to answer my point a minute ago. Like a Congressional Review Act disapproval decision is in fact new legislation. It has to go through both houses, it has to be signed by the president. So even then, like it still requires new legislation. And if it requires new legislation to grab power back, then it's not going to be enough to satisfy non-delegation.
Yeah, and I mean, I think Congress could sort of moot this case, right? I mean, Trent's right. You just change a few words here or there in the way that this statute is written that would allow the FCC to continue the universal service program. I mean, no one disputes that Congress has the authority to dole out billions of dollars every year for universal services. It's the way that this particular statute is structured that makes it unconstitutional. And I think that Congress tomorrow could change the statute and make it constitutional. It just, when it passed this statute in the 90s, it didn't do that. And I think that's why, at least for this particular statute, that's the problem, right? Congress needs to take action to correct it.
The next question, I don't know if you are aware of this case. They ask, what's the non-delegation issues in the Fifth Circuit's Horseman, Benevolent, and Protective Association cases?
I'm aware of it. I'm not going to claim to be an expert. My recollection is that it's a purely private non-delegation case. There's not that first layer of Congress to the agency. And that's actually an example of one where the Fifth Circuit held the statute unconstitutional, and Congress within a few months passed a new statute to fix it. Now the challengers claim that fixed one problem, but not another. And the Fifth Circuit actually said a second time, yeah, sorry, even the new statute's unconstitutional too. But as I understand it, I think the problem there is that at least in the beginning case, the original statute, the problem was that the agency had kind of off-boarded rulemaking power to a private entity. And that's kind of a form of private non-delegation. You're letting a private entity set rules and regulations. In our case, there's some of that. It's a little bit more of the failure to actually mind what the private party is doing. And if you just let the private party do what they want, and then that becomes binding without any kind of independent review by the agency, that's a different kind of private non-delegation violation. And they're different kind of only in degree, because in both cases, the problem ultimately is you have a private party in the driver's seat dictating rules and regulations or requirements that must be followed under penalty of law. And that's a problem. However, the agency gets there, whether it's on the front end by rulemaking or on the back end by just not ever reviewing what the private party does, you still have the same ultimate problem. I know that the parties in that case have sought, I think they've sought cert now. I know they've at least sought stays of the Fifth Circuit's mandate. The Fifth Circuit did not stay its mandate in that case. That's another one where there is a circuit split, undoubtedly, even on the new statute. And it's another one that the Supreme Court could take up if they want to address private non-delegation.
Another question is, what do you make of Adrian Vermeule's and Eric Posner's argument that agency rulemaking under a valid legislative delegation, as a statute that specifically delegates power, is an exercise of executive rather than legislative powers?
I don't think I've read their article, so I'm not sure of the exact argument that they make. I don't know exactly what the argument is. I think there is an argument that agency rulemaking, in a sense, could be executive power if what the agency is doing is saying, here's how we interpret the statute, here's how we're going to enforce it. And so we're giving everyone a heads up. I think there's actually benefit to agencies doing that. It's essentially an interpretive rulemaking. If they go beyond that and say, we're doing rulemaking that now private parties are required to follow, not necessarily because the statute says so, but because we say so when we're interpreting the statute, I think then it becomes a legislative rule. Like it's a forward-looking requirement that binds private parties and affects private interests, usually, not always, but usually, which I think is like the definition of legislative power. So again, I haven't read their article, so I don't want to say one way or the other, but that's just kind of how I distinguish different kinds of rulemakings in my head.
Yeah, and I don't think there's any problem with Congress passing laws telling agencies, have clean water, have clean air, and then allowing, agencies to enact or promulgate regulations in support of that, in support of those powers that have been, given to the agency, right? I mean, to me, that's constitutional. Here, it's and Trent pointed this out, is that it's a tax, right? That what Congress did here is it allows the FCC to raise however much money it wants and to set this rate every single quarter that is going to show up on everyone's phone bill. And it's something like 300 million cell phone bills every month and 100 million landlines. I mean, that little amount of money that's being collected from every single person, that's a tax. And it's important, I think, here is that that's about as legislative as you can ever get. So I don't think there's really a question here that you could argue that the Universal Service Program is somehow, an executive power that they're doing. This is almost purely legislative power. I don't think that you can sort of make that argument, at least in this context. And in other contexts in which Congress, delegates to agencies the ability to sort of promulgate the very specific rules, it's not doing it in this sort of purely legislative function.
So the next question is, are there other fees or other agencies that impose fees that may be impacted by this principle, or in this case, this decision by the Fifth Circuit?
Well, I'd say, remember first, it's a tax, not a fee, but setting that aside, the litigation in various forms has been ongoing for almost 3 years. We keep saying in our brief that we're unaware of any other program that operates like this, where the agency gets this power from Congress, very broad power. They then let a private party kind of run the show, especially with that, like it's approved by default thing where the FCC never even has to say that they looked at the numbers. We keep saying we never found another one. The government's never come up with another one. The Fifth Circuit in its en banc opinion says we can't find another one. So there are obviously lots of agencies that impose fees. The Supreme Court's decision actually in the CFPB case gets into this a little bit when they're talking about like what are agencies' powers and things. And there's perhaps an argument that, agencies have some kind of power to raise true fees Although it looks like historically, even then, Congress usually imposed some kind of limitation on it. So, like, we tried to find other statutes that deal with similar kinds of charges, I'll call them. And almost, I mean, I think actually in every case, Congress itself imposed some kind of limit. So you think about income tax, Congress sets the tax brackets. Like if we lose this case, why can't the IRS just set the tax rates? Not, do you, one particular company or person, fall within one range or another? But we, the IRS, now say everyone pays 95% tax. I mean, that would be constitutional under the, the FCC's and the government's arguments here. Even like Medicare tax, like Social Security tax, if you go find the original statute, it's Congress itself that sets like what exact rate is it, how is it determined? And the executive branch can engage in fact finding, like I said, do you, particular person, pay this tax or that tax? Which bucket are you in? But the idea that the agencies themselves could just set the rates is something that's, as far as I can tell, completely new.
And it's funny because this particular statute, the word is contribution. So it's not even, I mean, it's Congress using language that, they're calling it a contribution in the statutory text. And obviously, I mean, when in practice, it's not that. It's a tax, right? It's a mandatory fee or tax that's being paid every quarter.
Yeah, our brief played that up a little bit. For those familiar with English monarchy law, there were a few English kings who, when desperate for money, which is a recurrent theme, would force their subjects to pay money to them. But of course, they didn't want to pay it back, so they didn't want to call it a loan. So they would call it a loving contribution. And so we analogized that to the kind of the English requirement for loving contributions to the monarchy, because I mean, honestly, it's kind of the same thing.
It is a little ironic that in the Obamacare cases, the government wanted the thing that was called a fee to be treated as a tax. Now it wants the opposite. But
Yeah, we've been citing that case in our brief, saying the FCC can claim it's a fee, but as the chief said in NFIB, whether it's a tax for real for constitutional purposes is determined by the court, not by how it's labeled.
The next listener question was, if the FCC eliminates the USAC and took over all the USAC's functions, to what extent would there still be a non-delegation issue with the FCC in determining the contribution factor? And would that moot the case as well?
It would not, yeah, it would not moot the case because that's the first half of the Fifth Circuit's ruling is why the statute itself giving power to the FCC is probably unconstitutional. So I think if that were to happen at the most that would result would be like a remand to the Fifth Circuit saying, okay, look, all the private part is gone and that was your true holding that the combination was a problem. So now you actually going to have to answer the question of whether the statute's constitutional. I mean, 9 judges made pretty clear what they think, but they didn't actually reach a final conclusive holding on that.
Yeah, and I mean, the FCC, I think in their briefing tried to make the point that no, we're really paying attention to this. It's not that the deemed approve means that we're totally hands off. We're reviewing these numbers, and here's some changes that we made. And one of the things that they say in their brief is, look, we changed the rate one quarter, and what they did was they removed, I think it was like the thousandth place of a decimal because the computer system couldn't spit out the numbers right. I mean, there's no evidence that the FCC has put forth that's very persuasive, suggesting that they actually are interested in running this program. They aren't, and they haven't.
So I think the last question we're going to be able to get to today is from Mark Walsh. Can you talk a little bit more about how this plays out in practical terms? As you mentioned, this is 1/4 contribution at issue and that was remanded to the FCC. So how does this play out, assuming that you win on appeal in the Supreme Court? What happens? What's the process?
So again, it depends on what the Supreme Court would actually say. I guess let's imagine that they kind of just adopt what the Fifth Circuit said, that this combination of issues is a problem. I think they would say, we affirm the Fifth Circuit's decision. The Fifth Circuit's decision remanded to the FCC. The FCC would get it back. I don't know exactly what they would do. I think they would probably say, we're going to go back and independently review the numbers. And I mean, honestly, they should have been doing that all along. They should have been saying they were doing it all along. I just think they haven't been, so they can't say it. They should certainly do it going forward. I don't know that that gets them completely out of the issue because, as we said, there's still the statutory delegation problem, Congress giving it to the FCC. And so I kind of, I don't know, I suspect what might happen would be the FCC tries to do that. We then go back to the Fifth Circuit and say, either they've fixed the private non-delegation problem or they haven't, but claim they have. And so now the Fifth Circuit needs to finally resolve the statutory non-delegation issue and perhaps resolve whether the FCC's actually fixed the private non-delegation issue. Remember, again, the Fifth Circuit, even in its en banc opinion, did not actually vacate the FCC contribution projection number. And so I kind of suspect that the way it plays out going forward will just kind of turn on what the courts say upon remand. I'd be surprised if there's like this sudden upheaval. Again, I don't think it's going to happen, to be honest. There's no interest on any side to make that happen. Like we've tried to keep the case narrow. We've tried to minimize kind of the limit, the impact of it and that sort of thing. Because as Jeff said, like we want the court to address the non-delegation principles here. We don't want to get bogged down in practicalities in terms of parties kind of accusing us of, torpedoing a system and the whole thing's going to turn chaotic. And so we and obviously the Fifth Circuit have kind of taken steps to ensure that wouldn't happen.
Okay, with that, I would like to just affirm something that a statement that one of the users had sent in that I agree with as well. They say, Trent has done a marvelous job, but Jeff should take credit too for aptly representing a group of amici and supporting non-delegation doctrine in the Fifth Circuit and other circuits. I fully agree with that. And I think on that note, we'll be ending this and I will pass it back to the Federalist Society.
Yeah, on behalf of the Federalist Society, thank you so much to Jeff and Trent for speaking today and Devin for moderating. We're so grateful for your time and expertise. Thank you also to our audience for joining us. We really appreciate your active participation. You can stay up to date with announcements and upcoming webinars on our website, fedsoc.org, or on all major social media platforms. Thank you once more for tuning in, and we are adjourned.